Hi, good morning, good evening, all.
Yes, sir.
Hi.
Yes, sir. Good evening.
In the realm of healing, ethics is the compass and the law is the guiding light. When both converge, they illuminate the path to justice, compassion, and dignity in healthcare. Ethics whispers the conscience of the healer, while the law speaks the voice of society. When they walk together, they forge a bridge where science meets humanity and care becomes not just a duty, but a sacred trust.
Indeed, the relationship between medical ethics and health law forms the very backbone of a fair and humane health system. It is this alliance that safeguards the dignity of patients, empowers professionals to act with integrity, and ensures that the progress in medicine never loses the sight of compassion. Together, they create a framework where science serves humanity, where rights and responsibilities walk hand in hand, and where every decision in healthcare is guided by both wisdom and conscience.
Good evening, one and all. It is with immense pleasure that we welcome you to this momentous virtual gathering, a confluence of brilliant mind, distinguished guests, and passionate participants from across the globe. Today, we come together to celebrate the grand conclusion of the 26th International Seminar on the topic Medical Ethics and Health Law, hosted by the Kerala Law Academy Law College in collaboration with the Center for Advanced Legal Studies and Research, CALSA, and IQAC, KLA. This event stands as a testament to our shared commitment towards fostering dialogue, advancing knowledge, and shaping the future of ethical and legal practices in the medical field.
It is indeed a privilege to share this moment with such esteemed personalities gracing our virtual dais. It has been a day rich with dialogue, learning, and a reflection, a day when legal minds and medical ethics law experts join forces to explore the vital intersection of law, ethics, and healthcare.
To officially commence our valedictory session, we are privileged to welcome Selinji Ma'am, Assistant Professor at Kerala Law Academy Law College. Ma'am is widely respected for her unwavering dedication to academics, her remarkable academic excellence, and her invaluable role in shaping and guiding future legal professionals. I now invite Selinji Ma'am to graciously extend a cordial welcome to our distinguished guest as we commence this valedictory session. Ma'am, please.
Most respected Dr. Banerjee Chakasa, Dean, BSL, Senior Professor, Vellore Institute of Technology, Andhra Pradesh, Dr. Dandrivando Buddhichandu, sir, Associate Professor, University of Pajajaran, Indonesia. Advocate Nagaraj Narayanan, sir, Director, Kerala Law Academy Law College and member, Bar Council of Kerala. Professor Anil Kumar Kisa, Director, Administration, Students and Faculty Affairs, and other distinguished invitees, teachers, participants, and my dear students. A warm welcome to one and all present here. I am extremely proud to address you all on this auspicious occasion of the 26th International Seminar on the topic Medical Ethics and Health Law, put forward by Kerala Law Academy Law College and Center for Advanced Legal Studies and Research along with IQAC KLE. The confluence of these two disciplines, medical ethics and healthcare, is not merely academic. It's a moral compass guiding healthcare in the service of humanity. Medical ethics shape the values that govern the sanctity of life, the dignity of patients, and the integrity of professional, while health law provides the legal framework to uphold these principles in practice. In an age where rapid scientific advancements bring both promise and profound dilemmas, our discussions have been vital in bridging the gap between ethical ideals and enforceable rights. This seminar has brought together distinguished minds from diverse backgrounds to reflect, debate, and contribute towards building a healthcare system that is both ethically sound and legally robust, ensuring that compassion and justice work hand in hand. It's a matter of pride and privilege to welcome the legal dignitaries gathered here to participate in this event. Now, I would like to move on to the formal welcome address. It's our esteemed pleasure to welcome Professor Dr. Banerjee Chakasa, Dean VSL, Senior Professor, Vellore Institute of Technology, Andhra Pradesh. Sir is a distinguished scholar and expert in the field of international law, aviation and space law, international humanitarian law, international refugee law, and international criminal law, among other areas. With a remarkable career spanning over 2 decades, Sir has established himself as a leading authority in his
Ma'am Celine, your voice is unmute, ma'am.
It's our esteemed pleasure to welcome Professor Dr. Banerjee Chakasa, Dean VSL, Senior Professor, Vellore Institute of Technology, Andhra Pradesh. Sir is a distinguished scholar and expert in the field of international law, aviation and space law, international humanitarian law, international refugee law, and international criminal law, among other areas. With a remarkable career spanning over 2 decades, Sir has established himself as a leading authority in his field. With a wealth of experience in academia, research, and practice as a professor of law and dean at VIT Andhra Pradesh University and previously at Alliance University, Sir has demonstrated exceptional leadership and academic expertise. His tenure as a British Chevening Fellow at SOAS, University of London, is a testament to his scholarly achievements and contributions to the field of international law. Sir's research interests are diverse and impactful, encompassing areas such as international law, human rights, globalization, and international criminal law. His work on access to international justice, international humanitarian law, and business and human rights has been significant. He has made remarkable contributions to international law, authoring influential works on commercial dispute settlement in air transportation and custom as a source of humanitarian law. His distinguished career include serving as Associate Professor and Registrar at NLU Assam, Legal Advisor at the ICRC, and leading transformative projects such as establishing Assam's first children's court in collaboration with UNICEF. We are honored to have Dr. Banerjee Chakasa with us today, and we look forward to his valuable insights and contributions to our academic community. On behalf of Kerala Law Academy and my own behalf, we are truly grateful and we extend our heartfelt welcome to Dr. Banerjee Chakasa into this occasion.
Thank you very much. Thank you very much.
Now I take the privilege to welcome Associate Professor Dr. Dandrivando Buddhichandu to his prestigious gathering. As an expert specialist in information technology, law and privacy, Sir brings with him an impressive 30 years of experience in this field. His expertise spans a wide range of areas, including cyber law, telecom law, e-commerce law, digital economy law, data protection, and cybersecurity law. Sir illustrious career is marked by numerous achievements and prestigious appointments. He served as a special advisory staff to the Minister of Information and Communications Technology, Government of Indonesia from 2014 to 2019, and later as a special advisory staff to the Vice Minister of Tourism and Creative Economy, Government of Indonesia from 2019 to 2025. In addition to this, government roles, Sir has also had a significant impact on the private sector. Sir has supervised core founders of Indonesia's unicorns and decacorns in online transportation and digital payments, providing guidance on business model, stakeholder interactions, and market leadership. Sir expertise in privacy, cybersecurity, and ransomware case mitigation has been pivotal in shaping Indonesia's ICT landscape. He contributed significantly to top-tier ICT regulations, including Law Number 11 of 2008 on electronic information and transactions. With 15 years as an arbitrator at the Bani Arbitration Center, Indonesia, he has resolved numerous high-profile cases in IT infrastructure, digital management, and corporate actions. Academically, Dr. Buddhichandra holds a doctorate in law from the USA, earned with Fulbright, USAID sponsorship, and graduating summa cum laude. He is now an associate professor at the Postgraduate Faculty of Law, University of Pajajaran, and a distinguished author of ICT law books. It is our honor to have Dr. Buddhichandra with us today, and we look forward to his valuable insights and expertise. On behalf of Kerala Law Academy Law College and on my behalf, I am truly grateful and extend my heartfelt welcome to Associate Professor Dr. Dagjivanto Buddhichandra into this occasion.
Thank you.
Next, we have with us Advocate Nagaraj Narayanan Sir, Director, Kerala Law Academy Law College, Member, Bar Council of Kerala. Sir's deep commitment to academic excellence is evident in every facet of his work. As a mentor, he has touched the lives of countless of individuals, instilling in them a passion for learning and a drive for success. It is with great honor and gratitude that we extend a hearty welcome to you, sir. We are also privileged to have with us Professor Anil Kumar Kesa, Director, Administration, Students and Faculty Affairs. Sir's exceptional talent and steadfast determination, combined with deep understanding of the evolving landscape of education, makes him an invaluable asset to our college. Sir, with open arms, we welcome you to be a part of this event. And we also extend our warmest welcome to Professor Harindran Kesa, the Principal of Kerala Law Academy Law College, Professor Anil Kumar G. Sir, Vice Principal, Kerala Law Academy Law College, Professor Dr. Ajita Nair L. Ma'am, Head of the Department, Kerala Law Academy, Dr. Dakshina Saraswati Ma'am, Associate Professor and General Secretary of Kerala Law Academy, Moot Court Society, and Giridhar Sir, Gayatri Ma'am and Kulari Ma'am, Assistant Professors, Kerala Law Academy Law College and Faculty Conveners for this session. Now, I would also like to take this opportunity to welcome all student conveners, all the participants, IT team, technical staff, and student moderators for their contribution. Your enthusiasm and true dedication have made this event a resounding success. I hope the seminar will be a fruitful experience for everyone, and I welcome each and every one of you to this function. Thank you.
Thank you so much, ma'am, for your warm and gracious words of welcome. We extend our gratitude to you for setting the perfect tone for this evening. Next, we are truly honored to welcome Professor Dr. Banerjee Chakar Sir, Dean of the School of Law at VIT AP University and a Senior Professor of Law. Sir is a distinguished scholar and leading authority in international law, aviation and space law, international humanitarian law, international refugee law, and international criminal law. With over 2 decades of excellence in academia, research, and practice, he has served in prestigious positions, including British Evening Fellow at SOAS, University of London, registered at NLU ASM, and legal advisor to the International Committee of the Red Cross. His contributions range from impactful research and publications to transformative projects such as establishing ASM's first children's court in the collaboration with UNICEF. It is with immense honor that now we invite Dr. Banerjee Chakar Sir to deliver the valedictory address. Sir, please.
Thank you so much, and a very warm good morning to all of you. I think since morning you have been having very fruitful and very meaningful deliberations for this very important topic, that is medical and health laws, what you have been chosen for this 26th International Seminar. And it's a very good topic, the medical ethics and health law. And you have chosen a host of subjects, particularly to deliberate upon during the day. I'm sure you had a very, very fruitful discussions, and it's a very one of the important topics of what we have today. And I'm grateful to the organizing committee, and particularly the principal, and also the director of the Kerala Law Academy, and the organizing team of this 26th International Conference and Seminar on Medical Ethics and Health Law. And when I was invited by Dr. Dakshina ma'am, and I was very overwhelmed to see that the topic and the areas which you have been taken. And thank you very much for inviting me. And I'm very pleased to be here, and also very happy to associate with the Kerala Law Academy. And association with the Kerala Law Academy is a very long cherished one. I had an opportunity to visit a couple of times the beautiful Kerala Law Academy in earlier times, and where I had an opportunity to discuss the international humanitarian law with the faculty, students, and everything. And I always feel that it is my privilege and honor to be part of the Kerala Law Academy and a beautiful team of the organizing committee. Thank you so much. And coming to this, the topic today, I'm going to just take a few minutes to talk upon two important things. That is the important aspects of how this particular health law and health policies are orchestrated in the country as well as orchestrated across the world, and how they have been taken a different shape, particularly in the post 1995, the economic liberalization process which it took over, and how this particular health was taken in a different shapes. And also we had an opportunity to experience the effectiveness of enforcement of health law during the COVID-19, and where the governments have hurriedly launched their vaccines, and they have got sometimes it is elucidated that they have the positive impact, but there are also negative impacts on that. And there are also policies relating to human rights and access to healthcare. And when we look at all this, these three important things, it gives a very wide canvas for us to discuss. I'm sure you might have discussed all those things in the morning, but I will take only three critical important things. That is a post 1995, in the economic globalization, how our right to health has been viewed by the state as well as the corporate health system. And that if you look at that today, the constitutions have taken up very bold step, including that right to health and right to access to health care, which is a very wide canvas. And the Supreme Court of India and also several courts across the world have been given very good interpretations to it. But in spite of it, now the application and implementation is still subjected to, and also with the mercy of the state as well as the non-state actors like the private entities which have been occupied in this position in the healthcare sector. And today, when you look at that, this health is internationally, there is a lot of pressure from the pharmaceutical industry after this patent regime under the 1995 World WTO trade mechanisms have been incorporated. The trade-related aspects of intellectual property rights, the pharma sector has a heavily influenced, and they have taken a different leads for their what you call it as greed for money and corporatization of the health services. Coming to that in Indian context, India has also its share with regard to the providing access to the health. When you look at that in Article 21 and its implementation, and we have the very good jurisprudence given by the Indian Supreme Court, but I will only take one particular case in the context of 2013 Novartis Aegis case. I think all of you may be aware of it. In this particular Novartis case, I just want to refer and flag one particular issues. The courts have systematically told and said that, and we need to create an access to the health and health care, and to provide health to the people of across the country. And we also have the international responsibility of protecting the rights of the people as erga omnes obligations under the international treaty mechanisms. And when it comes to this particular opinion given by the Supreme Court in the AG Novartis case, it is very important to see the dimensions of the Supreme Court by referring and reaffirming the states and its attitude, as well as the companies which are involved in it. First, let us take the issues of the state. The issues of the state, the court categorically told the right must be the highest attainable standard of health, which was kept in Article 12 of the United Nations Covenant on Economic, Social, and Cultural Rights, and also in accordance with the General Comment 14 of the Committee on the Economic, Social, and Cultural Rights, where it says that the right to health requires availability, accessibility, acceptability, and quality with regard to both healthcare and underlying preconditions of the health. If you look at this in this particular framework of the right to health and health care, first of all, it should be non-discrimination, and we need to provide the physical accessibility and economic accessibility, that is affordability, and information accessibility we need to have when look at the point in which. And also with regard to the acceptability, you need to have the quality of the medical supplies and affordability to the people. When it to look at that in affordability to the people, the Supreme Court was very disturbed by the arguments made by the Novartis and their lawyers representing them. They clearly told that it is now evergreening of a patent must also be in accordance with the obligations of the Constitution, and also in accordance with the obligations taken by the India as a state party to the both covenants, that is International Covenant on Civil and Political Rights and International Covenant on Economic and Social Rights. When this particular debate, when the Supreme Court has given this particular judgment by refusing to grant the evergreening of the patent to the Glenveagh of Novartis, and the international community made so much of hue and cry by saying that India doesn't have an ecosystem for the innovation. Here, the problem is that when you are innovating certain things, should we only look at that satisfying the requirement of the corporate houses, or should we also look into the aspirations of the people, those who are suffering with the terminally ill diseases, where they are required to have a generic medicine or medicine which is bailing them out from the problems of their terminal illness. If you look at that, and India is considered as a pharmacy bowl, where India supplies pharmaceutical products across the world, and India provides a generic medicines. And India has got that record of providing accessible and affordable quality medicines in the third world countries. If companies like Novartis comes and challenges and they want to create the regime of evergreening and also claiming for 20 more years of the monopoly on the issues with regard to the evergreening and patenting of that particular affordability of the healthcare, that is challenging the very system of right to health and right to access to the health care. And in one of the judgment, Justice Madan B. Lokor, he made a very categorical statement, that is particularly with regard to the government of India and allowing and providing a particular access to the health. And that also you can read, there are material available written by the large number of people. And they are asking that, does the Indian Constitution recognizes the fundamental right to health care? If it recognizes, what are the contours which talking about that? And does this obligations extending to provide free or affordable medical care to the people? If the state has got that particular right, then what is the role of the non-state entity, that is a private healthcare sector, which is captured the entire market of the India? If you look at that in Article 38 and Article 47 of the Indian Constitution, which clearly says that state must secure a social order for the promotion of the welfare of the people. And also Article 47 of the Indian Constitution provides that a duty of the state to raise the level of nutrition and the standard of living and to improve the public health. If you look at that, these two articles, specifically along with Article 39 also, very important. And in India, we know that our constitutional experts and teachers says that, oh, come on, that directive principles of the state policy is not amenable to enforce by the courts of law. But I beg to differ with that opinion of those people and say that now these particular rights, that is socio-economic and cultural rights, must be read in the context of the civil and political rights regime which we have under the Article 21 of the Indian Constitution. That gives a kind of a platform for the people to provide and seek accessible to the medical and health care and affordability in the context of the healthcare sector. And here, there is another second point which I would like to say, that there are certain narratives have been created that only certain diseases have been promoted and medicines have been invented and they have been created for the purpose of making long-term impact on the people as well as making money by the pharmaceutical countries. And today, there are so many countries, still they are reeling under the various aspects of the diseases, and those particular diseases still they were not. What I mean to say that the traditional diseases which have been neglected by the healthcare sector. If I mention that, for example, malaria, dengue, and even the other diseases which are prevalent in the third world countries were completely neglected, and today there is a discrimination in providing a kind of an accessibility in physical to organized way for the purpose of alleviating the suffering of the people in the third world country. And here we have some kind of misconceptions about where we need to see that there should be a link between the right to health and right to access to the health care. But here we don't look into that. That is why the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, they specifically talks about that identifying these kinds of problems in a non-discriminatory manner and providing equality to further imply with the state, and the state must recognize the needs of the different communities and different people, my dear friends. And when we talk about that neglected disease and what I mentioned, here there are essential drugs as well as there are determinants to recognize that what the drugs must be produced for the purpose of addressing the problems of the diseases in the third world country, particularly the neglected diseases. This is very, very important. That is why the right to health care, a document produced by the organization of the Office of the High Commissioner of Human Rights, way back in 2018, which is a kind of eye-opener for it. Because they clearly talk about that, how these standards of the attainable standards of the physical access to the resources of the medicines and access to the healthcare have been drastically undermined by the countries across the world, including in India. So this is my second point, which I would like to talk about that. And the third point, which I would like to speak here, we need to look at that, all services and goods and facilities which are trying to provide access to right to health. And mind you that right to health contains a lot of elements, even access to the essential medicine, right to information with regard to the prevention, treatment, and control of the diseases, and providing nutrition to the maternal and child during their reproductive health system. So these are some of the important rights most of the countries they neglect. And today, if you look at that, in the post 1995, where the countries like India still reeling with this common misconceptions about the right to health. Further, if I take the important thing, the right to health always intertwined with other rights. For example, right to water and the right to food security. And this particular right to health, and always we need to have in consonance with the right to have adequate and hygiene, water and food security to the people. Because if without that, we cannot achieve what it is required to be. For example, unsafe drinking water, lack of clean water, inadequate hygiene, lack of sanitation, and poor management of the water resources lead to the most diseases which can be attributable to the unsafe water, sanitation, and hygiene. And it is very well recognized by the World Health Organization and its report in 2021 during the time of COVID, which was clearly saying that how we need to create a mechanism for the purposes of providing access to the allied services which can enhance to the right. Now, the point which I would like to leave it to you, that is, now we have the Sustainable Development Goals. And one of the Sustainable Development Goals by 2030, and within 5 years' time, we need to achieve them, the access to health and healthcare to all the people of this. If it has been corporatized, and the healthcare facilities have been corporatized, and if they have not having the access, how do you going to provide and achieve the Sustainable Development Goals within the span of the 5 years from now? So still, this is one of the contentious aspects of achieving the right to health and access to the healthcare by the state as well as the international level. So in this particular context, for the students and for the researchers of this topic, I always like to ask them to look at it, a kind of jurisprudence which was available and which created by the Indian Supreme Court with regard to the right to health, which recognized in the fundamental right, as early as in 1991, which I now need to look at that, how this particular rights have been categorically upheld by the Supreme Courts in its judgments, whether it is Ratla Municipal Council's case, or maybe with regard to the right to health is a fundamental case which is decided in the CAC Limited was Subhash Chandra Bose in 1992. And also it is where Mahendra Pratap Singh versus the state of Orissa. And all these are one of the classic examples which we are talking in the context of the India. And also now today, there is a difference of opinion in the Supreme Court's direction. One particular case that I already referred that is AG Novartis case. And AG Novartis case is an eye-opener, and the courts have specifically said that it is the duty of the state to provide access. But contrary to that, in 2017, in another opinion given by the Supreme Court, and they are saying that when the Supreme Court has given any judgment, they must concerned about the economic status of the state, and the judgments must be efficient for the purpose of resolving the state's development and enhancing its ability to provide access to it. But my question is that here you only talk about the efficiency of the state, or should we not look at the access to the justice by providing healthcare facilities to it? So these rights of things which we need to have a deeper study and a deeper understanding in the light of India's jurisprudence, and also in the light of international legal mechanisms which speaks about that, where the right to health and access to healthcare must not be compromised, because it is important to achieve the development. When we talk about that development in a state, if people are reeling under the terminal ill diseases, people are suffering, not having access to the basic medicines, to the neglected diseases like malaria, dengue, and other communicable diseases in countries like India, how we are going to achieve Vikasit Bharat, or maybe a developed country in 1947, that is become a mere distant dream without addressing these problems. With this, I conclude, and thank you very much. If anyone have any observations, I'm happy to respond to that, and thank you so much.
Thank you so much, sir, for your inspiring and thought-provoking address. Your words have been given us new perspectives on how legal framework can safeguard ethical medical practice. Now, we are deeply honored to welcome Associate Professor Dr. Dhanvindu Buddhichandu, sir, from the Postgraduate Faculty of Law, University of Panjaran, Indonesia, to deliver the presidential address. With an illustrious career spanning 3 decades, sir is an eminent expert in information technology law, privacy, cybersecurity, and the digital economy. He has served as a special advisory staff to the Minister of Information and Communication Technology and to the Vice Minister of Tourism and Creative Economy, Government of Indonesia, contributing significantly to nation's ICT policies and regulation. Sir has played a pivotal role in guiding the founders of Indonesia's leading unicorns and decons, as well as resolving high-profile dispute as an arbitrator at the BNI Arbitration Center. His academic journey includes earning a doctorate in law from the United States, graduating summa cum laude under the prestigious Fulbright USAID scholarship. A prolific author and thought leader, Sir's contributions have left a lasting impact on both policy and practice. It is our privilege to invite Associate Professor Dr. Thandivantu Buddhichandu, sir, to deliver the presidential address. Sir, please.
Thank you. Greeting from Indonesia. Distinguished guests, well-known scholars, esteemed speakers, and colleagues from every corner of the globe. It's with the deepest sense of gratitude and actual fulfillment that we can convene at the close of this extraordinary international seminar. Today, we have embarked together upon a rigorous and enlightening exploration into the intricate and rapidly evolving domain of medical ethics and health law. Let me begin with a vision, one that bridges the past and the present. Imagine a radiologist, her trained eyes tracking patterns on a mammogram, describing the subtle anomaly that experience and dedication have enhanced her to detect. Her diagnosis set into motion of life-saving course of treatment. Now, imagine that very same mammogram examined in less than a second by an algorithm, an artificial intelligence system trained on millions of images. This system identifies the same shadow, cross-reference genetic markers, and calculate with 98.7% certainty the likelihood of a particular cancer, recommending a targeted therapy before the radiologist has taken the first sip of morning coffee. This is not a scene for speculative fiction. It is a present reality. We now stand at the threshold of one of the most profound transformations in the history of medicine, one driven by artificial intelligence. AI is not merely an additional instrument by the clinical toolkit. It's a paradigm shift that is redefining the very essence of diagnosis, treatment, and the healing arts. Yet, with this extraordinary promise come unprecedented complexity. At the heart of the complexity lies an enduring human institution, the law, a discipline centuries old, grounded in reason, judgment, and moral principle. Today, we face the urgent task of reconciling the timeless principle of medical law with the disruptive capacities of intelligent machines. Let us consider first the promise. As Dr. Eric Topol has observed, we are entering a new era of medicine where the algorithm surpass human performance in interpreting scans and genomic data. We witness AI's triumphs in diagnostic, deep learning models that outperform seasoned specialists in detecting diseases such as diabetic retinopathy. In treatment, AI enable precision medicine, tailoring intervention to an individual genetic profile and lifestyle. In drug discovery, AI has shattered scientific bottlenecks. Define AlphaFold solved the decades-old challenge to protein folding, opening the vast new horizons for therapeutic innovation. These are not abstract possibilities. They are tangible advancements accelerating toward mainstream medical practice. But progress also casts long and complex shadows. And those shadows reside the most difficult and legal and ethical questions for our age. When AI participates in patient's care, who accepts responsibility when harm happens? The first challenge is liability and the black box problem. Advanced AI systems often operate through decision-making process, improves even the creators. If a misdiagnosis occurs, can we assign liability to the physician, the institution, or to the developer? The inability to trace reasoning in a transparent manner challenges the very pillars of tort law. Forcibility, causation, accountability. The law, which relies on answering this question why, is unsettled when the answer is silence. The second challenge is data privacy and informed consent. AI systems demand vast troves of sensitive data, yet our current regulatory frameworks, like HIPAA, GDPR, were not designed for algorithms that continuously learn and evolve. Can a patient truly give informed consent to recommendation generated by a process neither they nor their physician full comprehend? Without informed consent risk becoming a legal fiction. The third challenge is a bias and equity. AI reflect the data on which it is trained. If historical data embed social inequities, the algorithm will perpetuate and even amplify them, a phenomenon MIT Joy Bolowini calls the code gaze. In medicine, this could mean entire community misdiagnosed or rendered statistically invisible, transforming a tool of healing into an instrument of exclusion. Thus, we find ourselves at a critical stage. We cannot stop technology progress, but we must guide into with foresight and resolve. I propose a three-pillar legal framework to shape the responsibility integration of artificial intelligence into medical practice. Pillar 1, adaptive regulation. The velocity of technological change outpaces the deliberate cadence of lawmaking. We require adaptive regulatory bodies, like an FDI for algorithms, staffed with multidisciplinary experts in medicine, law, data science, and ethics. These bodies must engage in rigorous pre-market approval of medical AI systems and conduct a continuous post-market monitoring to ensure safety, fairness, and accountability. Pilot 2, redefining the standard of care. The legal definition of standard of care must evolve to encompass the realities of AI-enhanced practice. There might come a time when failing to employ a demonstrably superior AI diagnostic constitutes negligence. This will necessitate novel liability models, perhaps responsibility frameworks or no-fault compensation schemes that ensure patient compensation without endangering them to protracted litigation. Pillar 3, human in the loop centrality. AI must augment, not replace, the physician role. The law must safeguard the irritable human dimension of care, like empathy, judgment, and trust. As Dr. Topol reminds us, the true gift of AI is the restoration of time. Time for physicians to listen, to comfort, to heal. Colleagues, the integration of AI into medicine is not solely a technological challenge. It is a human one. It compels us to redefine expertise, responsibility, and the moral obligation of care. The optimal future is one which human wisdom is amplified, not replaced by machine intelligence. Building this future demands constant dialogue between technologists, clinicians, legal scholars, ethicists, and patients. As Satya Nadella has said, the partnership between humans and AI is not a choice, it's a necessity. The law must be the moral compass for the partnership, ensuring that these formidable new instruments are wielded to relieve suffering, advance justice, and preserve the sanctity of the doctor and patient relationship. The digital blade is in our hands. Let us ensure that it is guided by wisdom, foresight, and unwavering commitment to humanity. As we leave this seminar, let us remember. The future of medical ethics and health law is not predestined. It is ours to construct thoughtfully, courageously, and with an actionable faithfulness to our shared values. By our collective efforts, ensure that artificial intelligence in medicines become not a source of harm, but the force for healing, tempered by ethics, bound by law, and inspired by the timeless principle of human dignity. Thank you very much.
Thank you so much, sir, for your enlightening address. Your insights have broadened our understanding of the global dimensions of medical ethics and health law. Gratitude is the memory of the heart, and it is with heartfelt appreciation. With great pleasure, I now invite Pulari Dia Ma'am, Assistant Professor at Kerala Law Academy Law College, to deliver the vote of thanks for this valedictory session. A distinguished academician and expert in the field of law, Ma'am is admired for her deep knowledge, engaging teaching style, and commitment to shaping the next generation of legal minds. I now welcome Pulari Dia Ma'am to express our collective gratitude and formally conclude this session. Ma'am, please.
Most respected Dr. Banerjee Chakkasar, Dean VSL, Senior Professor, Vellore Institute of Technology, Andhra Pradesh, Dr. Dan Rivando Buddhichendu Sir, Associate Professor of University of Pachajaran, Advocate Nagaraj Narayanan Sir, Director, Kerala Law Academy Law College and Member Bar Council of Kerala, Professor Ankumar K. Sir, Director, Administration, Students and Faculty Affairs, and other distinguished invitees, teachers, participants, and my dear students, a warm welcome to one and all present here. It's my honor to deliver the vote of thanks at this valedictory section on the 26th International Seminar on Medical Ethics and Health Law, put forwarded by Kerala Law Academy Law College and Center for Advanced Legal Studies and Research, along with IQAC KLA. As I move on with the formal vote of thanks, first I would like to express my gratitude to Professor Dr. Banerjee Chakkasar, Dean VSL, Senior Professor, Vellore Institute of Technology, Andhra Pradesh. Sir, your insightful perspective on the topic provided valuable context and enhanced our understanding. Your words have beautifully framed the purpose and significance of today's event, creating a sense of anticipation for the knowledge sharing that awaits. I extend sincere thanks to you, sir, for your esteemed contribution. Next, I would like to express my sincere appreciation to Dr. Dan Rivando Buddhichendu, Sir, Associate Professor of University of Pachajaran, for delivering the valedictory address and bringing our event to a close. Your thought-provoking words have not only summarized the key takeaways from our discussion, but have also inspired us to take action and make a positive impact. We are deeply grateful for your presence, expertise, and valuable insights. Thank you, sir, for being an integral part of our event and for leaving us with a lasting impression. Now, I would like to extend my heartfelt gratitude to Advocate Nagaraj Narayanan Sir, Director of Kerala Law Academy and member of the Bar Council of Kerala. Your leadership and expertise have been instrumental in shaping the next generation of legal professionals. Under your guidance, Kerala Law Academy has become a prestigious institution renowned for its academic excellence and commitment to legal education. Thank you, sir, for your tireless efforts and dedication to the field of law. Your contributions are truly appreciated. Then I would like to extend our heartfelt thanks to Professor Ankumar K. Sir, Director, Administration, Students and Faculty Affairs, the Kerala Law Academy Law College, whose prudent leadership and resolute support have cultivated an atmosphere conducive to creativity and intellectual conversation between our students and profound professionals in the legal field. Thank you, sir, for your relentless dedication to the advancement of and prosperity of our institution. Now, I would like to express my gratitude to Professor Harindran K. Sir, the Principal of Kerala Law Academy Law College, Professor Ankumar G. Sir, Vice Principal of Kerala Law Academy Law College, Professor Dr. Ajita Nair L. Ma'am, Head of Department at Kerala Law Academy, Dr. Dakshina Saraswati Ma'am, Associate Professor and General Secretary KLA MCS, and Assistant Professor Giridhar Sir, Gayatri Ma'am, Salim Ma'am, for their great support and dedication. I must also take a moment to express my sincere appreciation to our dynamic student anchors, Jyoti and Nidhi, whose effortless moderation has contributed greatly to the smooth flow of this valedictory section. And at last, not the least, I would like to take this moment to acknowledge the tireless efforts of our technical and non-technical administrative staff, student convenience, and IT team. Your hard work, often behind the scenes, has ensured the flawless execution of this seminar. Finally, to all our participants and attendants, a heartfelt thank you. Your enthusiasm and active engagement is what makes events like this so impactful. We look forward to the insightful discussions and exchange that will undoubtedly enrich our understanding of this event. With that, I extend my sincere thanks to everyone who has contributed to making this section a success. Let us continue to explore, learn, and grow together as we navigate this evolving field. Thank you, everyone.
Thank you, ma'am, for your warm words of appreciation and for recognizing everyone who contributed to making this seminar a success. As the saying goes, ethics is knowing the difference between what you have the right to do and what is the right to do. Today's seminar has reaffirmed that when law and ethics work in hand, the future of healthcare will remain both bright and just.
Indeed. With this, we conclude the 26th International Seminar on Medical Ethics and Health Law. We carry forward the knowledge, insights, and connections we have gained today, confident that they will shape better practices in law and medicine alike. Let us leave this forum not only informed but inspired, committed to upholding the principles of justice, compassion, and integrity in every decision we make, for the benefit of individuals and greater good of the society.
It is an honor to extend our heartfelt gratitude to Advocate Nagaraj Narayanan Sir, Director of the Kerala Law Academy and a distinguished member of the Bar Council of Kerala, for gracing the valedictory session. Sir, your constant guidance and support have been a pillar of strength in making this event a reality, and we remain truly grateful. I would like to express our sincere gratitude to Professor Anil Kumar K. Sir, Director of Administration, Students and Faculty Affairs, the Kerala Law Academy Law College, whose steadfast dedication and inspiring leadership continue to propel our institution to greater heights of excellence. Our deepest appreciation also goes to Professor Harindran K. Sir, the Principal, the Kerala Law Academy Law College, Professor Anil Kumar G. Sir, the Vice Principal, the Kerala Law Academy Law College, Professor Dr. Ajita Nair L. Ma'am, the Head of Department, the Kerala Law Academy Law College, and Dr. Dakshina Saraswati Ma'am, Associate Professor and General Secretary of the Kerala Law Academy Moot Court Society, for your unwavering support and encouragement.
Subsequently, I would also like to offer my heartfelt thanks to our faculty conveners, Giridhar V. Sir, Gayatri S.B. Ma'am, Celine G. Ma'am, Pulari D.R.
Voice with me.
Subsequently, I would also like to offer my heartfelt thanks to our faculty conveners, Giridhar V. Sir, Gayatri S.B. Ma'am, Celine G. Ma'am, and Pulari D.R. Ma'am, Assistant Professors, Kerala Law Academy Law College, for their meticulous planning, tireless dedication, and commitment to making this seminar a grand success. We extend our warmest thanks to our diligent student conveners. Your enthusiasm, teamwork, and energy have been the heartbeat of this event. A special note of appreciation to our incredible IT team, technical staff, non-technical teams, participants, and the teaching and non-teaching staff for their tireless efforts in ensuring this event ran seamlessly from start to finish. On behalf of the Kerala Law Academy Law College, I extend our warmest wishes to each and every one of you for your continued success in all your future endeavors. We hope that all participants have gained valuable insights and cherished memories from this seminar.
Last but certainly not least, I thank each one of you present here for your gracious cooperation and active participation. This is Jyoti alongside Nidhi, signing off from this prestigious seminar. Thank you everyone. Have a wonderful day ahead.
Before we close, may I request everyone to join us for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे